At agenda item 6, which is a departmental briefing on the Sign Language Bill. So members, you have been provided with the following papers relevant to today's session. The copy of the bill at page 127, research paper there at page 139, delegated powers memorandum at page 198, and the previous departmental briefing paper at page 205. So I now like to welcome the following officials to our meeting this morning. We have Mr. Tommy McCauley, who is Acting Head of Sign Language Policy and Legislation, Sign Language Policy and Legislation Branch. We have Gerard Flynn, Deputy Principal, Sign Language Policy and Legislation Branch, and Patricia Leaper, who is Deputy Principal, Sign Language Policy and Legislation Branch also. So Tommy, I think it is yourself maybe that is going to make a brief opening statement, and then we'll get to members' questions.
Okay. Thank you, Chair. Good morning, everyone. As Chair has said, I'm Tommy McCauley, Acting Head of Sign Language Policy and Legislation Branch, accompanied by Patricia Leaper and Gerard Flynn, also from the branch. I'd like to thank the committee for the invitation to attend today, to answer any queries you may have and to provide the clarifications which you may seek to assist you with your scrutiny of the Sign Language Bill. The Sign Language Bill is enabling legislation which will place statutory duties on prescribed organisations to provide access to their information and services through British Sign Language and Irish Sign Language. We are aware that the committee has concerns that the bill has introduced contains, as quoted, extensive Henry VIII powers. Therefore, the Department has provided the committee with the Delegated Powers Memorandum, and I trust you have had the opportunity to consider its contents. The memorandum explains the purpose of the delegated powers chosen within the bill, the reason for the delegation and the rationale for the chosen control. The bill does not intend to make regulations with respect to the functions under policy remits of other departments. The demarcation of departmental functions and the need for executive approval on cross-cutting matters prohibits such course of action. Delegated power is the standard safeguard which is used in order to prevent the need for minor changes to primary legislation. Its use gives the department more flexibility to decide when or how to implement the facilitation of the use of BSL and ISL through consultation with the prescribed organisations and members of the deaf community, and they are limited to the cultural and linguistic needs of the deaf community. It does therefore seek to future-proof the bill, providing the Department with the ability and agility to make regulations quickly, to tackle unforeseen circumstances, which is important in the modern world where change is rapid and often unforeseen. This is a key lesson learned from the onset of the COVID-19 pandemic in March 2020, when the deaf community felt forgotten about, isolated, and extremely vulnerable, and with good reason. The community has sought assurances that this cannot happen again. This bill seeks to provide such assurances. Thank you for your time, and we're happy to take your questions. Thank you, Chair.
Okay, thank you. I'll start with a couple and then go to members. So, and I know you have set out there an explanation around the need for those Henry VIII powers. However, would you have concerns around the potential ability to keep the bill in a future time on track with what the department are trying to achieve? So, and what is it? Can you outline for us exactly what is it the bill is intended to achieve? How would the landscape look differently following this bill than it does currently?
The bill seeks to officially recognise both languages, British Sign Language and Irish Sign Language, and promote the interests of British Sign Language and Irish Sign Language. And if I could just compare and contrast that with the legislation in Scotland and the UK BSL Act. The Scottish legislation seeks to promote BSL. The UK legislation BSL Act seeks to promote BSL through the establishment of an advisory group. We've gone beyond that, and in addition to official recognition of both languages and the statutory duty upon the department to promote both languages, it will place statutory duties on prescribed organisations to provide reasonable access to their services and information. So in that regard, we've gone further than the other jurisdictions. How we do that is the question. had the bill been introduced back in 2016 when it was first consulted upon through part of the framework, the chances are, with the infrastructure in place then, it would look different to what it is now. While the Assembly wasn't sitting, we have embarked on an investment in the infrastructure that will support this bill through accredited qualifications that will provide the cohort of students and give them the pathway to qualify as professionals in interpreting, translation, or as teachers. What we're seeking to do, what came out of the COVID emergency, was the total lack of access to information. And as we all know, the first tool we had in the toolbox against COVID was public health information. And I had referred in our previous appearance in front of the committee that in early March I received an email from a member of the deaf community in a panic saying the deaf community are isolated. Some of the interpreters are seeking on a voluntary basis to translate information. Can you help? We at that point went to the Health and Social Care Board and we established a hub which led to the Health and Social Care interpreting contract, which is now established. You then had the rollout of the interpreters at ministerial briefings. We also funded a community initiative to translate COVID information from mainstream media. So those are things that were unforeseen in November 2019, let alone before then. And all of a sudden in March 2020 we went into lockdown. A lot of the things that may impact the bill going forward will be unforeseen. I mean, we just have to look at the global situation now to look at that.
Well, sorry, I suppose I do get that, and I know we will be dealing with that. I should have probably said from the outset, actually, just to indicate we really welcome the bill. I want to frame it that, and I should have done that at the outset. And I know there will be unforeseen things, and we will come as a result of committee. But I suppose I don't want to dwell too much on that today, rather than to say we will seek to see how we can satisfy ourselves that the powers transferred will be able to be used in a positive way down the line. So just as a further development of, and you're talking about the health issue there, so what bodies do you envisage as being prescribed organisations at this stage? Just to give me a further insight.
Okay, we have embarked on an exercise contacting our counterparts in the other departments, asking for lists of their public bodies for consideration under this bill. We have also embarked on another exercise looking at the CPD framework for interpreting, and it lists public bodies. So what we'll do when we receive those lists is compare and contrast them and to see are there gaps. Now, what we can't do, and it feeds into the narrative of Henry VIII powers, we can't dictate to other departments who should be their public bodies, but we can have a conversation with them, because the list that we receive, we will have to consult with those listed organisations in any case.
So the bill is designed to ensure that people who have additional communication needs via sign languages can access public services,
yes,
including health. So how does that square with saying that we cannot dictate to the Department of Health, for example, as to what our expectations are?
Because the legislation...
And particularly, Tommy, sorry for interrupting, particularly in light of the fact that there is peppered throughout the bill that we have in front of us, words like practical, reasonable, So how do we ensure, are you not seeking to hold them to account for what they must do?
Yes, what the bill will do, and I mentioned at the outset in my opening remarks, that it will recognise both languages, it will place a statutory duty upon us to promote both languages, which we will do vigorously. It also, at Clause 3, places those duties on prescribed organisations to ensure reasonable access to their services and information. And through our promotion role and through the mechanism we'll have for this, bear in mind, is the Sign Language Partnership Group. And that is chaired by us, the Secretariat's by us. It's represented by members of the deaf community, representatives of the deaf community, and also from other executive departments. Once the bill comes in, it'll place statutory duties on those departments to ensure that there is reasonable access to their information and services. So in that regard, those prescribed organisations are tied in. Now, you did mention there about there are issues of practicality and affordability.
Well, what I'm really saying is the use of the word practical and affordability something that could hollow out the intent of the bill, rather than the issues with it?
If, prima facie, you would think, okay, it's get out of jail cards for prescribed organisations, we can't afford it, it's impracticable. But if you look at that in detail, it's additional hurdles, hoops for them to jump through. Well, how can you not afford it? What's your budget? How's it impracticable? Now, the impracticable side would be probably, I've asked for an interpreter, I can't get one, which is why we've begun investing in an interpreter training programme, two in fact, one through a deaf training centre and one through Queen's University in Mayo. So there are statutory duties that will be imposed upon all prescribed organisations and permanently upon departments to ensure.
Okay, thank you. I'll go to members, and someone may be picking up on some of these issues as well, but thank you so far. Go ahead, Brian, please.
Okay, thank you, Chair. Thanks for your attendance today again. Just as a preamble question, when ISL BSL will be recognised as a language of Northern Ireland, does that apply? What other languages does that apply to? You might know the answer to that, but
Well,
what else is classified as a language of Northern Ireland?
British and Irish.
Yeah. English and Irish?
listen, although,
English and Irish,
yeah,
In legislation?
Yeah.
It's something I can follow up. It's just to know.
you have the Language and Identity Act
Yeah.
that deals with Irish language. English is accepted as an official language, although there's no UK constitution, so that's
unwritten constitution. Yeah. Okay. It's a side question. In terms of, as you described, that this is enabling legislation. So I am wondering, even when the bill passes, will it still be a work in progress, the whole issue, in terms of what is provided? And given that there was legislation in England in 2022, that's correct, and then there was also in Scotland and Wales. In terms of how this ends up in practical terms, that's what I'm trying to understand, and that's what many groups will be understanding, both in the public sector and in the private sector. And private sector groups which get public funding, we talk about some health services. And how do we end up at what is considered reasonable steps and for information services to be as accessible? And there's a clause there about affordability. How do you think it is likely to look? You couldn't expect every public service to have somebody standing waiting, for two sign languages, but they would need to have access to sign language services, perhaps online or by arrangement and so on. How do you think it'll flesh out?
Okay. If I could just deal with it in the context of the other jurisdictions that you raised, the BSL Scotland Act was enacted in 2015, and I think it promoted BSL and committed public bodies to develop plans to contribute to a national plan. I think the first national plan was 3 years after the enactment, with additional plans, I think, every 5 years, if I'm correct. The UK BSL Act established an advisory body, a non-statutory advisory body to the DWP Minister. And the aim of that is to produce a report for consideration by the DWP Minister. It may well have been the first one after a year or two after enactment in 2022. If you look at the Irish Sign Language Act, it was enacted in December 2017, but commenced in December 2020. And the rationale for that was to give space and time to develop the infrastructure to support the aims and the provisions of the legislation. Things like ensuring there are enough interpreters. Now, we've been trying to get ahead of the curve on that by investing in our interpreter translation and teaching capacity through funding of various courses. We are currently working with the British Deaf Association to co-design best practice. That will then inform the statutory guidance that will fill in, I suppose, what you're getting at, the missing pieces of the primary legislation. I mean, bear in mind that the primary legislation is there to set the infrastructure and the tone and the direction. Our aim then would be to include that statutory guidance in the sign language framework, which is being refreshed at the same time as this work is progressing. You may recall it was consulted on 2016, and in recognising that there's been quite a passage of time, we are refreshing that. That will carry the statutory guidance because it, to all intents and purposes, will be the strategy with action, recommended actions for public bodies to take forward. We then intend, once that refresh framework is finalised, to bring it to Sign Language Partnership Group for sign-off, then to bring it to the executive. Because the commitment first time round was that after the consultation, the framework would be brought back to the executive to consider. So this period of time on, the executive will consider, and then we go out to public consultation on the agreed document. So in answer to your question, as we've been, I suppose, holding our roadshows and presentations with the deaf community, we've been managing those expectations that day after enactment, the lights don't suddenly flick on. There will be a period of time while public bodies, as you say, get used to the idea, while we consider are there enough interpreters? One of the things we're considering for that is the health and social care model, the Regional Communication Support Service, which provides for free interpreting, lip reading and note taking for deaf BSL SL users and other deaf people who use health and social care services. So there will be, upon enactment, there'll be some things that can start straight away, and there'll be other things subject to the statutory guidance and to the infrastructure being in place. Might take just a little bit longer.
Two other supplementary questions, Chair, if I may.
Briefly, please.
In Scotland, I noticed that the 27 Act recognises different forms of BSL. So, anyway, are we assuming there's one standardised form of BSL? Or I don't know, is there a Scottish variant? But
no, if I could explain that, probably what you're referring to, I'm guessing, is tactile, hands-on, haptic signing, which the members of the deaf blind community use, and that is reflected in our legislation for BSL and RSL, that different forms of signing, Clause 12, a reference in this part to BSL or SL is either or both of the visual form of the language is commonly used and understood by deaf people, and the common tactile or non-visual forms of the language as used and understood by some deaf-blind people. So, similar to Scotland.
That will be the case here?
Yes.
Right. And last question, just about the prescribed list, and is it correct then that the department, I don't know whether the prescribed list will be in place and complete at the time when the bill is passing, or will it follow? And is it correct then that any amendments to the prescribed list will have to go through the Assembly by way of SR, or is it just something that the Minister or officials keep? But would legislation be required to amend it?
Yeah, it's the prescribed lists will be done through negative resolution, so the legislation will be made through an SL1, and it can be amended through negative resolution to remove or add a prescribed organisation. So that would be the mechanism that you'd approach that through.
At least it'll not be something that can be changed without us being aware.
No,
yes.
No. An SL1 will have to go to the committee. And just on another point, we can't actually make those regulations until we have the power. So we've got royal assent. But we expect when we get royal assent, those regulations will be more or less ready to go. So there'll just be a list of public bodies. We'll put an SL1 through the committee, and just can take it from there.
You think that might be ready?
Oh yes, we expect to have the list of public bodies ready as soon as royal assents come in. So we can list the public bodies. The only clause that we really wouldn't be commencing is clause 3, the duties on the prescribed organisations, until the proper structures, the statutory guidance is in place, and then once we've got all those in place, then we'll commence clause 3, which will place the statutory duties on all those prescribed organisations.
Okay, thank you, Chair.
Deputy Chair wants to come in just briefly on that point, and then I will be going to Kelly, Morris, back to Nicola, and Melissa. We do have your indication as well.
Thank
Go ahead,
you,
Nicola.
Chair. And I just want to go back in on that point about the removal of a public body or prescribed body. Has the department given any thought as to making it subject to affirmative resolution and actually letting it go through assembly properly? Because that's a major thing if you're removing a public body from having to provide this service.
The way we've considered this is just a list of public bodies, and it's a technical list of what is established as public bodies. Anybody on that list will be subject to clause 3. The position we're taking is that if you're a public body, you'll be listed, and to that element. So the only argument a public body would have not to be on this list would be argue that we're not a public body, and therefore we shouldn't be on this list.
And
So-
just on that as well, they must be consulted, all those public bodies, to be considered as prescribed organisations. We have to consult with them. So at that point they can make their case whether or not they should be.
Before the fact, they have to be consulted with. And
Yes, we have to
that.
consult with them in advance for the
That's-
final list.
But I just wonder, would you give it any thought then as to making it, let it go through the assembly and go through proper scrutiny for a public body to be removed instead of the department, albeit bringing it to committee, but being able to make that their decision yourselves?
The department don't think necessarily it needs affirmative, but if the committee of the opinion that it's something that is the interest of the committee and what's going to, it's an option, to go to the affirmative. But the benefit of the negative is that the SL1 will go to the committee listing the public bodies, and with the negative process, that can be changed and removed relatively quickly. So if for example, there was something in the future and there was a public body to be added who was operating not as the functions of a public body, maybe a charity or something, took responsibility for an area, and there were some circumstances, then that charity operating as the function could be added quickly to that public list. Whereas when you're going through the affirmative procedure, it'll take just a little bit longer to get that list.
And that's probably even more so for removing a public body. If a public body no longer exists, there's the administrative burden on the assembly, the department, the committee of going through that process of affirmative.
Right, we'll keep an eye on that. So Kelly, go ahead, please.
Sticking with that issue of the public bodies, I'm a bit confused. I think it's too vague. To be honest, I'm not a huge fan of negative resolution, but can I just check clause 4.4, public character and public bodies, that's two different things. So how does that line up? I spoke earlier today about for example, a dentist who is a private contractor says, I don't have the money, or I don't have the availability of an interpreter, so I can't provide this service for a deaf person. They're providing a public character, but they're not a public body. But will they be? That's very vague.
With regards to a dentist, they can avail of the Regional Communication Support Service that Health and Social Care provides, so it's free.
They may. They may avail of it.
They can avail of it.
But they may. But that's the thing. They could decide that it's.
Another example, I suppose, if you're looking at the Regional Communication Support Service, which is overseen by the Department of Health and funded by the Department of Health, but the actual contract is carried out by Sign Language Interactions, which is a private company. So they're carrying out a function of a public nature, so they would be, as part of the terms of the contract, expected to comply. Now, for that particular organisation, given that they provide interpreters, it shouldn't be a major issue. But any private enterprise that carries out on the contract a function for a public body, then yes, the terms of contract would be expected to reflect this, if it is deemed that it falls within the ambit of cultural and linguistic accessibility,
Okay.
for a deaf person.
I just think that the public character element in that clause sort of opens that up to a supermarket, or because it depends what you consider as a public character, public service.
If I could just add that, any information, clause 3 would come in there that provide reasonable access to information and services, and that's public information and services. So if a private organisation is carrying out that function on behalf of a public body, on behalf of the department.
To be honest, why are we concentrating so much on public? This is the Sign Language Act that's or bill, sorry, to help people who require sign language. The legislation should be far-reaching, because this is something we've waited on for a long time, whether public or private. And that's why I wondered, when we talk about affordability, in that clause 3, affordability and reasonableness, why was there not an inclusion of a reference to the Disability Discrimination Act and the requirements of it within that clause?
Because there actually is, if you read the legislation, clause 1, nothing in this part affects the operation of either of these, particularly as relevant to the rights of individuals in the deaf community, A, to any rule of law, or B, any other statutory provision.
Okay.
So the DDA, Section 75, all remain in place. They're all there as avenues of challenge for deaf people as they choose to go down that route. But this bill brings in cultural and linguistic access and rights.
Yeah.
So it doesn't take away from, for example, the DDA. There's a paper by a Flemish deaf academic, Martie de Mulder, and she made the point that sign language legislation makes explicit the implicit nature of adjustment under disability. So the benefits of this piece of legislation should inform and enhance DDA should a deaf person seek challenge under that. So it's not to replace it, but I don't think, I mean, if we start listing every other piece of legislation that this may come into contact with, then we'll have quite a...
On that, I'm a little bit concerned, having been through this process myself, consequential amendments that will impact on other departments. Although in Clause 7 it says that you can't confer specific functions on other departments, there may well be a requirement under the consequential amendments for other departments to have to update their legislation. Have you guys started any work with the other departments in that legislation to see how far-reaching this is actually going to be? Because it's, to be honest, the powers that are coming in this are quite strong, and we want to make sure that everybody complies and the legislation is updated.
We've not identified any consequential amendments to any other pieces of legislation that needs to be done through this bill. Clause 3 puts the duty, and that's in respect to the prescribed organisations. But in the future, we may need consequential amendments. And we're looking at considerations for stuff like written applications or written requests that may be in statute or in law. And it may be the case that we could put an exception into those pieces of legislation to say someone in sign can make this application in sign language. And that may require us the ability to consequentially amend other pieces of legislation that demands written things. So these are the sort of things that, as technology improves and access improves, we may have to move out. And issues like that is directly affecting the deaf community, written applications or interviews, etc., we may put consequential amendments around those issues.
My final questions is, it's more a request for information. Is there an opportunity for our committee, even if it's given to us in confidence, that sign language framework work that was done back in 2016, is there any report or summary of the findings for that could be shared? Because I know it wasn't published. And also, is there an opportunity to see the terms of reference for the sign language SLPG group? It's just to sort of work out what their terms of reference were on that one. Yeah, and the only other thing I wanted to ask about then was, for goodness sake, it's going out of my head. So you've said the Equality Commission for Northern Ireland, have they had any comment back to yourselves about the reasonable adjustments? Because affordability really grinds my gears, to be honest, because if someone's in a wheelchair and an organisation isn't fit to put a ramp in, they can be taken to the cleaners, but a deaf person, because of affordability and access to interpreters, could be excluded. But I'm just wondering, has the Equality Commission said anything to you guys?
No, we've had nothing back from the Equality Commission as of yet. Regarding the original framework consultation findings, we will seek permission to do that. We're happy to appear in a closed session that would help. Just on that, we began a refresh back in COVID, because again there'd been a body of time had elapsed, and also what we learned from COVID changed things drastically. So I refer back to a bill back in 2016 would be different to now, and looking ahead to make, as Jared was saying, in 5-10 years time could be totally different. So that's why we say we need the agility and ability react and not to isolate the deaf community. Sign Language Partnership Group terms of reference, yes, we can supply those. We are also, in parallel with the work on the bill, reconstituting the Sign Language Partnership Group. What we want to do is reframe the narrative of what actually consultation is. That there is a concept that consultation may just be either a formal public consultation or with deaf organisations. A lot of our engagement, stakeholder engagement and consultation, is with individual deaf sign language users, service users. An example would be when Carrickfergus Castle was our historic environment colleagues were looking at making that more accessible to deaf people. A deaf service user advised them. That's consultation. So we want to reflect that within our Sign Language Partnership Group, that it's not just organisations. And those are one of the organisations made a point to me at COVID that co-design, co-production is great, and that's been accepted. But they're kind of being overwhelmed. There's a consultation fatigue. So we want to broaden the model for consultation and reflect that in the Sign Language Partnership Group. So yes, we will look into the consultation summary being delivered, terms of reference, no problem, and we'll keep you updated through this process on the new constitution.
Thank you. Thank you. Yeah.
Thank you. Maurice, please.
Thank you very much, Chair. Thanks for your presentation. We've had a comprehensive brief before you came in there on the various clauses, and as the Chair's already said, we want to get this legislation over the line, but we want to get it over in a form that we don't have to revisit it again and again because we've made a mistake. But, you know, one of the things that I am really pleased about, as you said, that you intend to hit the ground running once the bill's enacted. And in preparation for that, you've had a significant increase in registered interpreters, and you're training 4 at the Foyle Deaf Association and 20 BSL and ASL MA students at Queen's. How many of those students are actually studying BSL, and how many are actually studying ASL? Are there, and I think this would be a silly question I'm going to ask anyway, are there any students studying both?
With regards to Foyle Deaf Association, out of the 6 of each language, 4 are now approaching their final assessment and waiting on their results. The Queen's University MA is now 19 students. I can provide the breakdown at a later date. I'll get those. I don't want to misinform you. And if it helps, I can get you a breakdown of BSL, ISL, deaf and hearing. None would be studying both.
I didn't think so.
Yeah, we have one, I think, bilingual interpreter who went through one of our previous funded training programs, but no, it would be BSL, ISL. For the point, I mean, the interpreters, and I think there's the Association of Sign Language Interpreters have a diagram that shows the length of time it takes to qualify as an interpreter, and I'm hoping it's tongue-in-cheek, make the point that it takes longer to qualify as an interpreter than it does as a doctor, because when you think about it, you have to go through the qualifications from beginner, all the stuff we did at school, and then do your professional qualifications and assessment for the interpreter training. So it is quite a lengthy process. It would be quite a cumbersome task to expect students to do both at the same time.
Yeah, look, I'm really impressed with the numbers you have training already, and I hope that the cohort increases as the years go on, because it's nice having a sign language bill, but if we don't have enough interpreters to enact that bill, we're really in trouble. So I'm really pleased to see that you're concentrating on that part. Thank you, Chair.
Thank you, Maurice. Deputy Chair.
Thanks, Chair. I just want to go touch again on the consultation part. I know in clause 5 and clause 8, I think it is, they both mention the department will consult with at least one person or group preparing the department to be acting on behalf of the deaf community. So I think that's just a bit weak, to be honest, that you could get away with just consulting with one member or group in regards to this here, whether it be issuing guidance or those procedures for making new regulations. So would you be willing to rejig that there, so that you'd be having to consult with more people or groups?
I suppose going back to my previous answer on the Sign Language Partnership Group and that very issue of one person, we wanted to reframe the narrative that consultation has many gears. With regards to the Carrickfergus Castle, they consulted with a deaf BSLS, who happened to be bilingual, BSLSL user, to advise them on what would be the right model for making it more accessible to the deaf community. Now, we think that was reasonable. The deaf signer thought that was reasonable because you're seeking the input from a service user. The Regional Communication Support Service provided by the Department of Health has an advisory board upon which we sit, but it also has a deaf service user as part of that. So really, I mean, I suppose that's a drafting mechanism to make the point that consultation is much more than just going out to deaf organisations, and also to provide that agility for lower level issues to consult if we need to with one or more people. In reality, we have the Sign Language Partnership Group. So in reality, that anything certainly that we have oversight for in our department will be going through the Sign Language Partnership Group, on which you have multiple organisations and you will have deaf individuals, and likewise we would expect other departments to do likewise.
Thank you for that there. I just want to move on. I know we're short in time. I just want to move on to clause 9 and the duty in the department to publish a report every 5 years monitoring the impact of the Act. Can you explain to me why 5 years was chosen? And again, it can be, I know Kelly touched this as well, it can seem like quite a long time. Would there be any consideration of reducing that there time?
I mean, if I can get the rationale for the actual 5 years, and it refers to the earlier member's question about will the benefits, I suppose, of the legislation be realisable straight away, and the answer would be no, because it hasn't happened anywhere in the world, not just on these islands. With regards to the Irish Sign Language Act, I'd spoken with colleagues, our counterparts down there, and the authors of the NDA review after 3 years. Now, what came out of that was, even though the Irish Sign Language Act was enacted in 2017, commenced in 2020, that 40% of public bodies were unaware of the legislation's existence, and 30% of requests for interpreter hadn't been met. And that really sort of hit home. You need time to build up the infrastructure. The NDA report wasn't overly positive on the achievements to date. So what we wanted to do is give the legislation time to bed in, give us time to have the infrastructure in place, give prescribed organisations and departments time to develop their action plans, which is going to tell the deaf community in consultation with them how they're going to deliver on this. Otherwise, you could shorten it, but you're almost certainly going to have a skewed negative viewpoint. But it's not, I think Minister had mentioned on the day, he's open to other considerations.
Can I just add to the Deputy Chair, it could be 5 years and 3 years thereafter.
Yeah.
The reason why I say that is because if you go for 5 years, you could effectively wipe out a full mandate without a report being delivered. I know that a lot of other bills come through with, obviously, yes, you're absolutely right, given a longer period at the start, but then after that, 3 years. Yeah.
I could just add that we will be evaluating this on a yearly basis anyway. This would be your statutory report after 5 years. I mean, there will be information available in the interim up to that 5 years.
And if I could just add to that, I mean, the wording is that the first reporting period is the period of not more than 5 years. So a bit like yourselves, with it's your limit, not the target for the extension, that'll be ours. If we think things are going really well, be assured we will be looking to sing our own praises, and we'll be there as quick as possible. So there, on that, it's an open issue. But the rationale is to give prescribed organisations and ourselves time to make effective change.
Just as we follow up, May, just on in relation to the consultation piece, and I do get what you're saying, Tommy, around being able to be flexible enough to take a quick piece of consultation around something of a lesser nature, but surely in general terms, for more critical things, you should be consulting with more. And I suppose the concern of the committee is that clause would allow the flexibility, but also allow a minimalisation of consultation going down. So surely it should be at least 2 or more organisations. And should those organisations not be on the face of the bill rather than being chosen ad hoc as things go on? Could you not strengthen that provision by increasing the need and naming the organisations?
We are seeing organisations come and organisations go. I mean, the voluntary and community sector is very stressed financially at the moment. For the Sign Language Centre, was a founding member of the Sign Language Partnership Group. It's no more. We brought in Foyle Deaf Association, the teaching centre, but what we're looking to do with our new constitution for Sign Language Partnership Group is have the right organisations that represent the deaf community in Northern Ireland and the right service users, non-affiliated deaf individuals. And under the action plans, bring it back to best practice and statutory guidance. Our guidance will be that you must consult through the Sign Language Partnership Group, or should, and there you'll have the British Deaf Association, RNID, NDCS, Association of Sign Language Interpreters, Visual Language Professionals, Action Deaf Youth, Foyle Deaf Association, and multiple individual deaf professionals as service users.
Okay.
That's okay, yeah, thanks, thank you.
Okay, going to Melissa then online.
Thank you all. Like, you're all very welcome. You referred there a number of times to the Irish Sign Language Act of 2017, which actually had created enforceable rights for sign language users to access services. Now, why has the department not created enforceable rights as the Irish Sign Language Bill did do? This is a comment that is often made by people that this bill, we'll say currently, is much weaker than the Irish Sign Language Bill of 2017.
Yeah, I can answer that. The Irish Bill does put enforceable rights in, but they're also reasonable. There's a reasonable test in that. We have also put enforceable rights in here in relation to Clause 3. So we're putting a duty on prescribed organisations to do interpretation and services, which is quite similar to down south legislation.
And the statutory guidance that will inform that access will be developed in consultation with the deaf community. As a reference, the best practice that will feed into that is being currently drafted by the British Deaf Association. It will be brought to the full Sign Language Partnership Group. That will be the basis then for the drafting of the statutory guidance. So in that sense, again, we go back to the consultation. There are many gears of consultation that we're employing here. Co-design, sign-off of the actual design document that will feed into the statutory guidance that will inform reasonableness and access to services as laid out in Clause 3. And these will place statutory duties on prescribed organisations and on departments permanently.
So it's effectively an expectation in the future rather than from the outset, i.e. in terms of enforceable rights.
I mean, as soon as the statutory guidance has been consulted on through the framework and then it'll be commenced, I would draw the parallel with the ISL Act. The 2017 it was enacted and its first review 6 years later. There are issues, as I've mentioned, with regards to 40% of bodies not knowing of its existence and 30% of requests for interpreting not being met. We don't want to go down the same avenue of legislating for failure, which is why we're investing in the infrastructure now, and hopefully other departments will come on board with that as work on this bill progresses, and not just post enactment. I mean, now going forward, we're already in discussions. We made that clear at our last Sign Language Partnership Group last week that we expect departments to bring their expertise, knowledge and resources to this issue.
Yeah, I can totally appreciate that in terms of having the infrastructure in order to cope with it. Thank you.
Thanks, Melissa. Tommy, or whichever of you, Clause 7.3 of the bill delegates power to the department to assign statutory functions to a range of bodies. So I'm just wondering, what are the nature of the functions that you anticipate being conferred under those powers?
That will be in the exercise of clause 3. The statutory duties to, amongst other things, take reasonable steps to provide access to services and information. Anything you want to add to that?
Yes, I could add something to that. 7.3, it enables us to make regulations that will put these, the gains, the reasonableness, the affordability into regulations. But that's not the approach we're taking here. We're looking at codifying statutory guidance. So reasonableness, affordability will all be defined within the guidance which is co-designed with the deaf community, rather than leave that definition up to individual departments and prescribed organisations. We get consistency by having statutory guidance saying, here's your sign language plan, you get a request in, you take these procedures, you give this reply in relation to it. That 7.3 enables us, if, for example, there was an area that wasn't working or was disputed about, to come in and actually put through regulations, actual functions that they were required to act, rather than following the guidance. You will actually have to follow the regulations. So the regulations in 7.3 are somewhat of a safety net for us to address issues that may not be working through the guidance, or may, for example, be disputed in the court and needs rectified, maybe through regulations. But we've no intention to put these duties on 7.3 through regulations at this point at all. We expect that the statutory guidance and the sign language plans developed by the departments and prescribed organisations will address all the issues around accessibility, affordability, reasonableness. And that's the approach. But we need that power in 7.3 in case there's some dispute on a particular issue, maybe around affordability, and we have to actually come in and regulate and define what affordability is under law. If, for example, a court took a different approach, we can correct that in regulations.
And again, if I could just add to that, we look at the regional communication support service model, that it provides for video relay service, video remote interpreting, and other, I suppose, technological services that at the outset of this journey from 2015, when we first started, may not have been available. As things evolve and the advent of AI may bring more opportunities for technology, then it says that willing to exercise more functions in the interest of the deaf community. So things that don't exist now may change. And again, we keep going back to that term. We would need the ability and agility to move with the times, I suppose. So functions mainly now would be providing access to your information and your services through BSL, ISL, through hands-on tactile BSL or ISL.
Well, Charlie,
I was going to say this is an important part of what the committee needs to think about and would like to see is what those regulations you're intending to bring forward might look like, because it does say at the power to make regulations, the department may make regulations, not must make regulations. There's no timetable on it. We've already had experience through the department, for instance, the gambling regulations. We still don't have guidance out on that a few years later. I just have concerns that we don't have enough information at this stage about those regulations, and it's conferring the law that is being written is the one that confers the responsibilities on the other departments. And I'm a bit worried that we're talking all about affordability instead of actually how this is going to improve the lives of people who use sign language. So why is it may make regulations, not must make regulations?
If I could just come in there on the affordability issue, and may and must make regulations, and the ability and agility of the department to reflect that. If you look at, again, the health and social care model is...
I just say it's not the be all and end all, because we have a lady who went into labour and her and her husband were deaf and they had no help.
Yes, that is true, and I've had emails to that effect. But again, with any service, you will have that. But it's a big sea change of what was there beforehand. Now, if access to information and services the big money ticket will be interpreting or translations. Now, how do we do that? And that's what we're looking at now. We're involved in an exercise of collating data from the CPD framework, whereby public bodies can draw down interpreters. They pay for it themselves. So we're looking at how many requests have there been, what has the cost been, but not only that, why have other public bodies not used them? Is it they haven't had a request or they haven't had the budget? So that has informed us to, I suppose, what is really a binary consideration for access to information through interpreters. Do you go with a status quo CPD framework and people draw down and pay for their own interpreters, or is there a case to be made for a regional service similar to the health and social care model, where it is centrally funded, reflecting the fact that this legislation, as we know, we are currently the coordinating department. The legislation will make us the lead department, and other organisations have their own responsibilities. In essence, it's an executive bill in that it's cross-cutting and it needed executive approval. Therefore, the consideration is, as you were, and individual public bodies, departments pay their own way, or is there a case to be made for a central service, at which point it's free at contract, and which point, I suppose, the affordability consideration becomes null and void. So that is another body of work. And I know, I sense the frustrations from the committee that we're taking a lot of powers to make regulations because we don't know all the answers currently. We hope to soon. We hope to develop the framework soon, reconstitute the Sign Language Partnership Group, and have clarity on how it's going to be funded, as you were, or a Northern Ireland model. And at that point, those can all be embedded within the legislation. If we do it now and it can't be done, you have primary legislation that will need changed.
If I could just add as well, the way we're approaching this with the statutory guidance and the code of sign element, so we're looking at approaching the deaf community to give us what's accessible, what's reasonable for the deaf community, rather than looking at a statutorial sort of, definition of reasonableness. By producing that and working with the deaf community, we hope not to have to make regulations around reasonableness or effectiveness, because the statutory guidance and the sign language plans that we develop by the prescribed organisation should be able to handle that. And also we can adapt quicker with the statutory guidance. So if we see bad practice or something, we can change that and move. If we put that down in statutory legislation and we're trying to adapt to accessibility or reasonableness in statutory legislation, then it's a long process to get that changed. By taking the code of sign element and working with the deaf community, we will change the guidance and put that message out very, very quickly and listen to best practices.
Yeah, it's taking advice before the issue rather than afterwards, and that our whole modus operandi has been working in partnership with the deaf community along this process.
Thank you. Morris, quick one.
We very quick, and just when you're bringing back the information for me on the BSL, ISL, could you also maybe get me the criteria needed? How many members of the deaf community have we got that need BSL? How many have we got that need ISL? And how many people are in training for both, to make sure that we have an adequate supply for the majority as well as the minority?
The previous written briefing that we applied to committee deals with that, and as does the explanatory financial memorandum, and it highlights the difficulty of gathering data, which realistically, when you look at it, makes the case for the legislation, in that as public service providers across 3 benefits, we sought numbers of BSL-ISL users. They weren't collated, but they were able to tell us 16 types of deafness. So it kind of makes the case that the deaf community has been misrepresented. Parks and Parks, as part of that work in 2012, released a research paper which highlighted the difficulties in collating numbers of sign language users, and it's not just in Northern Ireland, it's across the piece, other jurisdictions in the world, because that information hasn't been collated. One of the intents of this benefit outcomes of this legislation will be that we could compel prescribed organisations to start collating such information. Now, we even looked at the health and social care contract, But the data whereby we get volumes of calls made or requests for interpreters made, that is multiple. I mean, people go to the doctor multiple times, or recourse to dental appointments, etc. We can give you the number of students in interpreter training programs, and we've committed to doing that alongside the terms of reference of the Sign Language Partnership Group and the consultation report summary from 2016.
Can I just add, I'm sure it makes it very difficult for you, the fact that people who are a bit older, who use sign language, had to go to school down south, and therefore they're ISL users, whereas the younger generation of sign language users go across to Liverpool or here to Jordanstown. So we have that age breakdown of the users of different languages as well. John Carberry's brilliant on the history of sign language. You know.
Interesting you say that. I had a meeting last week with 2 deaf service users. We funded a BSL Heritage project and an ISL Heritage project for the deaf community to collect their story, to contribute to, you know, their lifetime. And they made the point, I mean, we were talking about ways of translating the signed video footage into BSL and ISL could be used at Queen's students, and they made the valid point, and I did know before I even said it, that older generation BSL ISL users use a different form of signing. It's heavily influenced by fingerspelling. Younger generation of signers will have, like we do, a more expansive lexicon and vocabulary in signs. So almost like a Matroisky doll. You have BSL, ISL, older generation, younger generation.
Okay, thank you. A quick one, just in terms of the criteria for the prescribed organisations. No, we've talked essentially the criteria is that they're a public body. Are there other criteria available? Have you drafted criteria at this stage? And are those available for committee?
The other criteria is carries out the functions of a public body. So you could have, you know, a charity or someone who's carrying out the functions. We haven't identified at this point in time any organisation that's carrying out the functions of the public body. At this point in time, the lists we have are just basically departments and their ALBs.
Okay, well listen, thank you. So I know this is the first sort of engagement on this, and I welcome actually the detail and the exchange and the interaction with committee. I also have to say welcome the repeated indications around co-design, and that is absolutely welcome. However, I suppose a wee concern is around we're operating in a climate at the same time where the department have indicated a changing approach to co-design, or the minister has. So I suppose that's something the committee will want to ensure that strong co-design element remains within this important area. And I think you have demonstrated that up to now, and I'd like to see that continuing. I know we will have a number of questions following our session that was just in with examiner for statutory rules around legal issues, which we may want to compile and forward to you for a response, a written response, and I'll ask the staff to look at that. But for today, thank you for that, and we look forward to working with you. And what I get a very strong sense is all of our desire to create a really strong piece of legislation that will create real benefit, and that will continue into the future. So thank you for that today. Thank you. Thank you. Okay, members, any further actions in, members? So I think there are a number of things. Could we get agreement that we write to